The gentleman from North Dakota, Mr. Armstrong, is recognized.
Thank you, Mr. Chairman. And I think sometimes we might not, these aren't always ideological differences. As somebody who practiced criminal defense in both state and federal court for a decade, I have a drastically different impression of subpoenas being issued than prosecutors necessarily do. So we just had that discussion about the subpoena and about Rule 6E. So I would start, because I do think context matters. So I would start with Professor Turley. Do you agree with that back and forth analysis we just heard?
No, I don't. I think it's a mistake to compare subpoenas used in conventional practice with a subpoena issued by a congressional committee. They are different creatures. Yes, subpoenas that are issued in litigation are often too broad. They're often setting the table for fights. This is not some litigant in a state court fighting over a subpoena. You have to tie your requests carefully to your authority to demand information. What I would suggest to my friend is that if Bill Barr had actually complied with the subpoena as written, he would have violated federal law.
Thank you.
And this committee also said, by the way, that they believed that Rule 6C did not bar Attorney General Barr from releasing the information. I think that's also not true.
Well, and I have 2 points to that too, because I mean, this is a political body for various reasons. So there are a lot of people on both sides of the aisle that have spoken up in print, on TV, and all of those things. And I can tell you that up until the day of the contempt hearing, there's nobody out there saying that 6E information is not supposed to be disclosed. I mean, the narrative and the way this was working was the entire unredacted Mueller report. So I'm just going to do this really quickly. Professor Shaw, if Attorney General Barr would have provided a complete and unredacted report, would he have violated the law?
I mean, I think the law protects grand jury material. Yeah, I would agree with that. Yeah.
Mr. Rosenweig, do you agree with that?
I agree, though I would say that nothing in the statute prevents him from asking a court for permission to provide that Rule 6E material.
I agree with that, but nothing in the statute or our authority compels him to do that. And a subpoena surely doesn't compel him to go to court.
A subpoena surely does not compel him to go to court.
Professor Kinkoff, do you agree with that?
Sure.
Okay. So I think it's important. I mean, this blanket assertion of privilege happened the morning of a contempt hearing. I mean, this protective assertion of privilege happened the morning we were going to hold the Attorney General and Barr in contempt for information that he could not provide in compliance to the subpoena by law. And one of the reasons I bring that up is because we've talked about this. Professor Turley cited, I think the total report is 98.5% is available to certain members. Of the obstruction side, I think it's like 99.9%. And the reason I'm saying this is because when I read all these cases, whether it's Holder or Oversight v. Holder, and we're dealing with all this, a big portion of the analysis is on research or on accommodation and negotiations. And I think Professor Turley talked to it about, the questions about conditional waivers. And so we talk like if the people on this committee who have access to that in a secured setting, like that becomes the end of it. But that's typically where we would start having this negotiation and accommodations. And that's what's happened in prior cases. That's what happened in Holder. That's how we worked our way through this. And I mean, when you have one party controlling one branch of government and one party controlling the other branch of government, there is going to be combat. There is going to be back and forth. There's going to be those. We saw it in the Holder case, and eventually they went to court, and there had been documents provided over the course of months and months and months. But that didn't happen here. And outside of everything else, there was no time for that to happen here. This all happened in a span of, a very, very short period of time. So how do you deal with with the negotiation and accommodation part of this after you've held a contempt order on a person who can't comply with your subpoena? And so I'll start with Professor Shaw.
Well, I think the process continues. I think that accommodation can be ongoing today and next week, and that was true before the committee contempt vote, and I think it remains true. So I think that it is incumbent on both this committee and the White House to attempt to, de-escalate if possible. I think it's only possible if there's meaningful attempt to provide information to the committee, which, as I understand it, although I agree that the timeline is short, in some ways, I presume the decision was made that it doesn't matter how much time you give to a party that is providing no information. You may as well proceed quickly to the next stage of negotiation if there is absolutely no cooperation forthcoming.
And I don't necessarily disagree with that. My point would be that there was no cooperation on either side. I mean, we were saying you're providing the whole thing, and he's saying I can't provide the whole thing. And I think that I'm out of time, so I just say that the negotiation and accommodation part would work a lot better if the contempt order wasn't in place. And to quote somebody on the panel from a hearing we had earlier, I think Congress has met the enemy, and sometimes it is us. This was in a different context, but I think we're fully aware of what we're doing, how we're doing it, and why it's not the most effective way to accomplish our goals. Thank you.